Hello, my name is Mike Cortina. I'm a partner at the law firm of SmithAmundsen, and today I'm going to be talking about tips for documenting commercial construction loans. The first point that I would like to address would be the Illinois Credit Agreements Act. This statute is very important because what it does, it makes it so that any deal with a commercial loan must be in writing and must be signed by all the parties and must show a general term in order to be enforceable. That becomes crucial because any borrower who thinks that they might have a deal with a lender, if that deal is not in writing, signed by all the parties, and show a general term of what the deal is, then it simply doesn't exist. It's considered a strong form statute of frauds, and Illinois courts have been uniform about enforcing it. So if a deal is not in writing and signed by everyone and does not show all of its terms, it simply does not exist. The next point that I would like to discuss are things called simply bank forms. Often banks and other financial institutions have their own loan forms or loan documents that they like to use. These documents, unfortunately, are not always accurate or, frankly, even legal. I have seen actual bank forms, bank documents that they have paid for that do not comply with the law. One such form was a change in terms agreement that changed the terms between the lender and the borrower. This change in terms agreement laid out what the terms were and was signed by the borrower only. The lender did not actually have a place to sign these forms, so the lender never did. Because of that, that change in terms was unlawful and unenforceable. So the idea of relying on bank forms to be accurate should not be in anyone's mind. You should always double check to make sure that all forms are proper and legal. The next topic that I would like to discuss is the use of checklists in commercial loan documentation. When reviewing documents prepared by another attorney, the first thing I always do is see what sort of checklist they have to see what forms they believe are required. Or if I am creating my own documents for a deal, the very first thing I prepare is a checklist. Attorneys have done deals many times. They're often very similar deals, but the actual documents themselves that are needed for a proper transaction are often different, even with very similar deals. So the idea of relying on memory is not a good one to use when preparing commercial loan documents. The very first thing that should be prepared or reviewed is a checklist. There's no reason to rely on memory, and a checklist should be used for every deal. The final point that I would like to discuss are confessions of judgment. These are clauses that exist in loan documents that allow a lender to obtain a judgment against the borrower once an event of default exists without even informing the borrower that they have gone to court. A lender simply needs to obtain an attorney to sign a confession of judgment, file a lawsuit against the borrower, and then simply obtain the judgment without ever even serving a summons on the borrower. Such clauses are disfavored by courts. However, they are legal in Illinois and will be enforced in a court of law. These types of clauses are often seen in commercial loan documents, and if you are representing a borrower, that is the type of clause that you want to review and discuss with your client in order to determine if it is something that you wish to negotiate with the lender. If you're representing the lender, the same is true. You want to make sure those clauses are in those loan documents, and if the borrower wishes to discuss them, then they can be negotiated. For more tips on documenting commercial construction loans, please view my full presentation recorded during the ISBA program, The Construction Industry, Shortcut to Disaster, and available in the ISBA Online CLE archives.